Starting now, today is the 239th Friday group meeting. First, felicitation to our Pragyan Pradip Sharma, senior advocate, recently designated as a senior advocate. Is on November 29th.
Correct.
November 29th. So we are all most welcome. And he also addressed our Friday group on first time on 14th July 2023. That is a 181 Friday group meeting. The topic was copyright law in India. The second time he addressed on 22nd September 2023, that is 190th Friday group meeting, rights of personalities, so special reference to Indian celebrities. The today's topic is anti-dumping laws and overview. Before felicitating our Pragyan ji, I request our Uzaifa, I am the senior advocate, one of the prominent senior advocate of this country. So he also, sir also addressed, Uzaifa ji also addressed on 16th Friday group meeting, that is 27th 11th 2015. The topic was freedom of speech, right to criticize. Thank you very much, sir. You spent your valuable time. Now
We should have him again now. It's been too old. He recorded.
Uzaifa ji is giving on behalf of Friday group to Pradeep ji.
He given such a pleasure. Thank you.
Thank you.
So nice.
Come closer.
Yeah.
Camera. Uzaifa ji will address us to few words. His view overall senior designations and our Friday group 1 or 2 minutes. I'm highly grateful to you. Please.
So I hadn't bargained for a speech. I'm assuring everyone. But I'm delighted to be here. We all knew there's some good news today. The first is that we are, felicitating Pragyan today. And the second piece of good news, and I'm sure all of us, for both the pieces of good news that we have, join me in celebrating that, is that thank God it's a Friday. I've known Pragyan quite well. Earlier, in my early days in practice, before I was designated, I used to travel quite a lot. And often Pragyan and us, more than in court, used to often meet at airports. Because he also truly had an all India practice. And in my junior days, when I used to travel and he used to travel a lot, we used to end up meeting, exchanging pleasantries at airports and often be together at flights. And I miss the long chats that we used to have, often seated next to each other. So Pragyan's now, it's a very important milestone in his career to be designated as a senior. And he will now assume a very different kind of a role in court. He will get out of tedious drafting, and I think he'll be addressing the court on much larger issues. And I wish him all success for the future. The topic that he's addressing us on is, I don't know too much about it, but in my earlier years at the bar when I used to practice in the tribunal, anti-dumping is one subject which had just started. It was very new. And I think the rules, etc., took a while.
Yeah.
And I think before all that crystallized, I think it was mid-90s, if my memory is right.
Definitely. Much later.
But I remember my father not speaking about anti-dumping, but speaking about the pernicious effects of other countries. The effect of other countries' goods being dumped into your country at a time of crisis. And I remember my father telling me when I was very young that during the India-China war, or just before that, our markets were flooded with cheap Chinese goods, and they would include fountain pens, etc. And my father would often go around urging people, saying, please don't buy these Chinese goods, because ultimately they are aimed at destroying your economy. And that's what the enemy country wants to do. So this is my first brush with the concept of, anti-dumping, where ordinarily as a consumer what you feel is that you're getting something cheap, why should that be stopped? And in fact, why should anyone stop anything which is inexpensive, and of good quality into your thing for a lesser price, and why should one care whether that person is willing to make a loss? But it is at that time, for the first time, that the pernicious effect of this kind of a, an onslaught of economic ruin which is thought to be brought upon your domestic industry, that it dawned upon. So I wish you all the best. I'm sure this is going to be a riveting debate, but I apologize for having to leave a little early. But I will catch up with it. And fortunately, thanks to Mr. Rao, now everything is available on the on camera and on the YouTube. So wish you all the best and enjoy the debate and enjoy the weekend. Thank you very much.
Thank you very much, sir.
Thank you, sir.
Okay, my regards to your father.
Sure.
Thanks.
Thank you so much.
Former Chief Justice of India, I am his son.
Yeah.
Everyone knows about this.
Thank you.
Thank you for the kind words.
Thank you.
You come.
Yeah.
If you request me.
Yeah, right.
On top is the microphone. On top is the.
I think let's put it here.
Come down.
Good evening again. It's a Friday evening, so I'll not detain everybody's weekend outings. So we'll try and keep the whole discussion very, very short and crisp. Yet, try and give out as much information as possible. First of all, I would like to thank the entire Friday group for inviting me here and also giving this lovely bouquet of flowers, felicitating me for the my designation as a senior. Especially Seshu sir, I have known him for now several decades actually. So he used to be a very good friend of my, another close friend of mine called Sridhar Pottaraju, who has given several lectures over here, and he is instrumental in introducing me with Seshu sir. So the topic of today's discussion is anti-dumping laws in India and a broad overview. Now, what do we understand by the term anti-dumping? Now, we all know that the world is a free world, the trade has to be normally without any barriers, correct? Because there are countries can of course trade, and this is exactly what used to happen historically all throughout. But what happened as time went by, people saw that if there is a product or if there is an article in one country which is manufactured at a much cheaper rate, that used to be sent to another country at a very, very nominal or a very low price, as a result of which the people in that domestic country, okay, those manufacturers used to suffer. So the whole, what is happening today is the concept of nationalism that we all see. So this concept of nationalism is actually, several decades earlier that used to happen, and in economics. So what these domestic industries did, they started, putting their hand up and saying, we want our rights to be protected. We don't want to be eaten up by imported goods from outside at a cheaper price. We want the domestic industry to grow. What happened as a result of that? That certain countries which were open countries, open economies like the US, etc., had in 1930 itself gotten this anti-dumping laws in place, etc. But on the whole, under the UN umbrella, for the first time, it is the GATT agreement, which was about 1947, 1948. 1947, the GATT treaty actually happened. It was implemented from 1948. So that was the first time that something was more or less codified into a broad outline as to how the barriers, the trade would be without barriers, yet certain trade remedial measures could be imposed on tradings by different member countries of GATT. Now, what does it do? what is anti-dumping therefore? So dumping, as we know, is dumping of cheap goods into another country. So that's dumping. And anti-dumping is stopping that dumping into that country, obviously. But that's not the actual definition, or the broad definition in the Act is that, let's assume, what is dumping margin? Dumping margin is basically the cost of production in the domestic country and the export price. So if the cost of production in the domestic country is say 100 rupees, and that good, now that particular article is imported into India at 80 rupees, okay? So what is the dumping margin? The dumping margin is 20 rupees, right? So, and tax is imposed on that 20 rupees. So that's the direct kind of a thing. Now, how did, the whole thing come into India? Now, India, as we all know, before Narasimha Rao ji actually came into as a PM as far as the country is concerned, that was in 91, 92, we were always a very closed kind of an economy, right? So 91, 92, we opened up the economy, as a result of which several, companies from abroad started coming and building up industries here. The trade was made much more free. So India realized the need for certain trade remedial measures, and as a result of it, certain amendments were made to the Customs Tariff Act. Now, why Customs Tariff Act? Customs Tariff Act because anti-dumping primarily is a tax issue, right? So if it's a tax issue, so therefore it is in the tariff. Simultaneously, what the legislature also did is it brought about something called anti-dumping rules, okay? So the rules basically define the process by which the anti-dumping duty would be determined, how the provisional duty, how the final levy of anti-dumping duty, etc. would be imposed. I will go into that in a bit of detail as we go along. But as of now, so there is an act, there are certain provisions in the Customs Tariff Act, and there are certain rules which are called the anti-dumping rules. In short, the name is much longer, probably it will take the whole of the evening if I have to go into the name. So broadly that is that. Now, okay, so now I have already said, so what is the provision under the Act? The provision under the Act is section 9A of the Customs Tariff Act. Now the Customs Tariff Act, and that is the machinery provision as far as the Customs Tariff Act. So what does it say? So it says that if a product is exported into India at less than the normal value, then, and on importation of that good into India, customs duty can be imposed, or anti-dumping duty can be imposed, not exceeding the margin of dumping. So I explained earlier, the margin of dumping is 20 rupees. But it is not exactly the margin of dumping as far as India is concerned. India has followed the scheme or the regime that is there as far as the US is concerned. So we don't, although the Act provides for the levy to be up to the margin of duty, we don't go by that. We go on to the actual injury that is caused to the domestic industry, which is more than always is normally less than the margin of dumping. Now, again, so that's the margin of, so as I explained the concept of margin of dumping, there is a interesting formula for that. So what is that formula? It is the cost of production minus the export price. Okay, so as I said, if cost of production is 100 rupees, export price is 80 rupees, the dumping of margin is, so that's the dumping margin. Now, what is the export price? The export price is the price at which the goods have landed into India, right? So that's the export price. Now, there are certain situations where the person who is importing the goods or the person exporting, they are related. So the prices might be even more lower, or in some cases higher. So then the designated authority, who is the authority to go into issues as far as anti-dumping is concerned, he will find out what is the actual export price. based on a reasonable assumption, reasonable basis, and then determine that, right? Now, next concept is the concept of normal value. Now, how do you determine normal value? So, again, like export price, normal value is the price of a comparable article. So for example, the microphone here. So there might be not this very article or this microphone, there might be something similar. So which is, again, I'll come to those definitions which are there in the rules. It is called the like article. I'll come to that concept of like article. So how do you determine the normal value of a particular product then if there are no sales of that product in the open market? Suppose the good is being dumped into India from China. So if then there are no sales within China itself, how do you determine that? So normal value would be determined by first ascertaining the actual cost of production. Then you will add up onto that certain selling expense, advertising expense, administrative expense, and some bit of transportation, and also profit. So once you do that, then you determine the normal value of the particular product. So it's broadly that. So once under section 9A, if anti-dumping duty is imposed on that particular product, you cannot impose other duties like customs duty or GST, etc. Those can be imposed, right? But additional countervailing duty or safeguard duty, which are other remedial measures, they cannot be imposed. So I'm so sorry, I should have said this before. Like anti-dumping, Article 6A of the GATT agreement also provides certain other measures for prevention of goods coming into India at a much lesser rate to prevent the domestic industry. There are three broad principles, like one is anti-dumping, the other is countervailing duty, and the third is safeguard duty. Now, countervailing duty is like, for example, the government gives a lot of subsidy. Even in India, for a lot of products, you get a lot of subsidy. As a result of which, the cost to the company of that product comes down, right? So, say Chinese government gives electricity free, the transportation is free, the factory is given free because it's all these plants, etc., are government owned. So a lot of things are subsidized. So how do you put countervailing duty? You will go and inspect those goods. You will figure it out, okay, this is free, that is free. So you will, whatever benefits the government is giving, you will impose countervailing duty and make it a balanced kind of a deal. Okay, so that's what countervailing duty is. The other remedial measure is safeguard duty. Now, what is safeguard? Safeguard duty is an emergency measure. For example, at some point of time, like Josefa sir was mentioning, that during the war, a lot of products started getting imported from China, etc., at a sudden particular point of time. So, as an emergency measure, the government of India imposes something called a safeguard duty. So, automatic, there is no too much of an investigation process, etc. To balance out and protect the Indian industry, they will go and impose this safeguard duty. So, broadly, it is that. Then, for how long can anti-dumping duty be imposed? Anti-dumping duty can be imposed for a period of 5 years from the date of initiation. Okay, obviously it can be renewed thereafter. I'll come to those periods later. Now, if it has to be renewed, it can be renewed for another period of 5 years. But the interesting part is, and that in the note that I'll circulate of the case laws, you'll find a couple of cases which says that between the expiration of the duty in the first round and the initiation in the sunset review round, there cannot be any gap. So it has to be a continuous, only then there can be a review. Okay, so we'll go through those cases later on. Then the review decision or review has to be initiated before the expiry of the anti-dumping duty. So these are the two provisions. The other aspect is that section, there are three provisions in the Customs Tariff Act, 9A, 9B and 9C. 9B is basically that there are no other remedial measures. I have already dealt with that. So 9C is an appeal provision. Now it says appeal is only provided against the determination or review by the CESTAT, that is the Central Customs Tribunal, which is there in R.K. Puram here. and the period to go to against an order of determination by the Director General, the appeal is filed within a period of about 90 days. So, what powers? So, we all know by the supercassette judgment and all a plethora of judgment that if a power is not specifically conferred on the tribunal doesn't have that power. So, SESTAT has been given the power to confirm, modify or annul. So, power of review is also been given as far as anti-dumping is concerned. But the power to hear these cases emanating out of the order final finding is on the president. So the president has to sit along with two other members. So it is not a general bench that hears it. So since considering the importance or importance of this kind of a structure and the fact that it is a new jurisprudence, so therefore these kind of matters are given a slight bit of prominence. So this is the broad structure as far as the Act is concerned. Or based on the powers provided in the Act, so anti-dumping rules were enacted, and it's a long name. So it's called the Customs Tariff, Identification, Assessment and Collection of Anti-Dumping Duty on Dumped Articles and for Determination of Injury Rules 1995. So that lays down the entire process as to how the designated authority and officers under the designated authority has to conduct itself in order to find as to whether a particular article or a product which is coming into India is dumped or not. Okay. Now, who can actually initiate an anti-dumping action? Okay, that's a very prime issue. Who can initiate? Now, the law says, that is section 2B, that is, it is only a domestic industry who can actually initiate or kickstart anti-dumping investigation. So, is there a criteria? Yes, there is a criteria. Either suppose this microphone. So the entirety of the microphone industry should join together. So normally all these people have associations. So that associations together would have to file that particular action. Or it has to be a majority of the producers in India. Right? Now if however any producer is related to an exporter, then that gets excluded for the purposes of determining the majority, right? So this is the funda by which you can actually go ahead and file an action of initiating anti-dumping action. The designated authority, however, on getting certain information, can also has a power to suo motu initiate an anti-dumping action. Okay. Now, what kind of articles against which, what kind of articles should be imported? Does it have to be this very same article, or it can be something else also? For the legislature again, 2D specifies that dumping will not only sustain against that very article but also like articles. Like articles would mean a similar article or something which has the similar characteristics. Okay, that's how it is defined. So just to exactly tell you what it says, or any other article which although not alike in all respects has characteristics closely resembling those articles under investigation. So that's the broad scope under which the articles fall in. Now interested party, now who all should be called for this entire investigation? Now as far as this investigation is concerned, the persons who are called are obviously the domestic industry. All the domestic industry will be given a notice for this. Now, there are several known exporters, people who export those goods into India, and those data is available from the customs. So they get the information and the addresses of these importers from there. They are given notice. And also the exporters, importers, people who actually import these goods into India. So these people are given the notice, and based on this, all these notices, anti-dumping proceeding or investigation is initiated under Rule 5 of the Act. Now, before I get into that, I need to say that the authority that actually investigates or looks into this is a person called the designated authority, or it is called the DGTR, Director General Trade Remedies. Okay, and it is comes under the Ministry of Commerce. Absolutely. So it is a Ministry of Commerce. But interestingly, once the final finding is given, the final finding has to be notified by the Ministry of Finance. So I'll come to that. There's a huge conflict between Piyush Goyal and Nirmala Sitharaman now going on. So I'll come to that aspect, and a lot of litigations based on that are happening as far as the Delhi High Court is concerned, where our ASG is appearing on the other side. So now, what does the designated authority do? Designated authority has to first investigate, then he has to identify, okay, so this is the like article, and then recommend that, okay, this is the duty I'm going to be imposing. And then if he finds that the dumping is continuing, then he again says that, okay, I will review my decision and continue it for another 5 years, right? So, as I said, now for initiation, he will determine the dumping, whether there is a dumping margin, etc. Then he will determine whether there is an injury. Now, what is an injury? Now, merely the fact that the goods have come into India is not good enough. At a lesser price than what it is manufactured, or the cost of production is not good enough. Now, there has to be an injury to the domestic industry. Is that the domestic industry has to be having some kind of losses, okay? However, there is one more aspect, very interesting, which is called the causal link. Now, it is not only important that there has to be a margin, a dumping margin and an injury, but there has to be a causal link between the dumping and the injury. So, the injury has to be a direct result of the dumping. If the injury is happening to the domestic industry as a result of a lot of external factors, employee cost high, lack of proper management, infrastructure, etc., that's not as a result of the goods coming into India or goods coming into India at a lesser price. So it's very important that this causal link is established and put out in the open by the domestic industry. Now, how is the investigation initiated? The investigation is initiated through first a public notice is given out and notified in the official gazette, and all the other parties are thereafter asked. There is a whole list, timeline. This is a very timeline specific investigation, and each day is, time is of the essence, as they say. Time is of the essence as far as the entirety of it is concerned, right? Then another important aspect of this anti-dumping investigation is that for the purpose of investigation, the domestic industry as well as the parties exporting have to give out what is their cost of production, their mechanism, how do they actually go about marketing. So a lot of information that they give in order to actually assist or help the designated authority is confidential, and if a competitor finds that information, it will be leading to a lot of taking out their trade secrets or whatever it is. So you can also give information on a confidential basis to the designated authority, and unless and until that person giving the confidential information says that you please disclose this, you cannot disclose, okay? But there is an option for the designated authority to say, okay, although you have claimed confidentiality, this information is not confidential. So an option is given to the other party, do you want to claim confidentiality? So if he says, okay, yes, then that information cannot be given. But an adverse inference can be drawn as far as that is concerned. But if he says, okay, give, only then that information can be passed on. Now how is the injury determined? As I said, there is a whole process, whole investigation that is done over a process of a year. And within that year, the designated authority and its team has to determine as to whether, what are the causes and what are the, I mean, how that particular causal, whether the causal link is established, to what extent the causal link is there, and whether it has the potential to materially retard the establishment of a new product or a new like article in India. So if these criteria is met, then he goes ahead and, you know, kind of determines that injury margin, etc. So now the investigation process normally takes about a year and a half. I mean, actually it can extend by a special order of the Government of India to about 18 months. So at some point of time, like we asked for this interim relief, domestic industry says, oh, if you impose the anti-dumping duty after 18 months, the whole idea of the domestic industry will completely be wiped out. So please impose some kind of a provisional duty immediately. So what they do, they have the power under Rule 12 to issue a preliminary finding. At that preliminary finding, they normally, based on a prima facie kind of a determination, they impose something which is called a provisional duty. Interestingly, this provisional duty can be escalated or downgraded depending on what comes out during the course of the investigation under Rule 6. So, however, there might be cases where the provisional duty has been imposed under a wrong belief, or the investigation reveals that, okay, no anti-dumping duty is actually leviable. So then what they do, there is a provision under Rule 21 of the Act where they have to make an application, and the excess duty that they have paid is normally refunded. Or for example, the provisional duty is say 20 rupees, but final duty is actually 10 rupees. So that differential is then refunded back to that particular company. Now, the DGTR also has the power to, you know, terminate the proceedings, anti-dumping proceeding. Suppose he finds that the domestic industry is not interested in proceeding. So why waste time? So he'll close it. Then there is no evidence found in the investigation, he again can close it at any point of time during the course of it. Thirdly, if the dumping margin is less than 2%, okay, तो क्या फायदा है इतना करके, there is no point going ahead. So he will close that and he'll terminate those anti-dumping proceedings. Another very important aspect, or a unique aspect as far as anti-dumping proceeding is concerned, is what is called, after the investigation is over, when it is nearing the end of the entire process, what they would normally do is something called the disclosure statement, or under Rule 16 is called disclosure of information. Now what is disclosure of information? Like in the US we have this concept of draft orders. So it is technically like a draft order. So they will give out the various reasons and the evidence that has been found against the parties on which the dumping duty, anti-dumping duty is to be imposed. And they will ask us, okay, this is going to be our final order. Do you have anything to say against this? Okay. So again, US also, normally what they do, the US Chancery courts, etc., they will tell the lawyers, okay, you guys, both of you sit together and prepare a draft order. So this is technically a draft order where both the sides are asked to give comments. And if something very material is found, they will obviously tweak and correct all of that, and a final finding is then, given by the designated authority. Now, as I said, the final finding, very interestingly, again, as I said, time is of the essence as far as the whole scheme of anti-dumping is concerned. So therefore, it has to be given within a period of 1 year. Now, as I said, the government may, in specific cases only, by giving reasons, extend this period to 18 months. And there is also the power of the power in the designated authority to impose this duty on a retrospective basis. Now, suppose the designated authority goes ahead and recommends imposition of duty. Is it certain based on that the government will impose? The answer is no. The government, what the Act says, that is Rule 18 says, that the central government may. So, at certain cases, the government says, no, I will not impose. because I have very good relationship, say with, I can't say Canada now because, so say with USA. Modi has good relations with Trump, says, okay, I'm not going to impose, even though a dumping margin or a causal link, etc. has been imposed, I will not impose any duty as far as the goods emanating or coming into India from the US is concerned. That's a policy decision. So that discretion has been given to the government not to impose anti-dumping duty, to even though it's detrimental to the domestic industry. So that power has been given. Now, as I said, another line of cases and another line of, is on the question as to when should you start. So as I said, it is anti-dumping duty is for a period of 5 years, and thereafter it is extendable for another period of 5 years. So suppose the anti-dumping duty is expiring on the 31st of December 2024, okay, the review proceeding has to start before that, right? Now, if the review proceeding starts before that, only then the central government has been given a power under the proviso to section 9A to extend the duty for another period of 1 year, okay, so that the review process can be completed. So why so? Because the Supreme Court says, and the Act also specifies now after the amendment, that there can be no gap in the duty, okay. So there need not then be a fresh investigation all over again. So this, it's called the process of sunset review. So when the sun is setting on the first round of imposition of anti-dumping duty, that is towards the fag end of that 5 years, so there is a sunset. So once there is a sunset, or there is going to be a sunset, so you file this review application, and normally that is done. So as I said, so therefore, and lastly, as I already mentioned, section 20, rule 21, which provides that in case there is a party who has paid the duty and the final finding says no, this duty has been wrongly imposed, then obviously that amount can be refunded. So I told Seshu sir, I have a arbitration. So what I did for your benefit of everybody, the law as far as anti-dumping is concerned is, and in terms of, I'm not talking of case law jurisprudence, okay, or precedent jurisprudence, is not very, extensive like we have for other areas. So it's very specific. There are about 6-7 very interesting Supreme Court cases on different aspects. And there are some bit of high courts here and there which has dealt with several aspects of anti-dumping law. I prepared a 2-page case law summary. So I would request Seshu sir to circulate. And if there is, if there is any queries or whatever, you can put it up to Seshu sir. And I will be very happy to, in the group itself, to answer those queries, etc. But one aspect is there is a huge debate, and there are several judgments where, there was a dispute as to what can be challenged. Because what are you aggrieved against? Are you aggrieved against the final determination, that is the section 17, or are you aggrieved against the notification that is issued by the central government? So when the designate or DGTR issues an anti-dumping duty, there were a lot of companies who directly go to the CESTAT or come to the High Court saying that the designated authority has violated principles of natural justice. So therefore the entire investigation is wrong. To the Supreme Court and several High Courts, Gujarat, Bombay and Delhi, they have all said, no, you cannot go against the final finding under section 17. Because that is nothing final. Because what the designated authority says here is only a recommendation which it is then given to the central government, right? So the central government may or may not. So if the central government is not imposing a duty, your petition is premature. So, but now again, as I said, there is that dispute between the government, two ministries, because the final finding is issued by a organization which is under the Ministry of Commerce, whereas there is the final finding or the notification is issued by the Ministry of Finance. So the Ministry of Finance in the last budget brought out a notification by which they actually omitted one of the words called determination or order. So now what they are trying to say is that you go and challenge the final finding. You can't come against the notification issued by the government of anti-dumping, because that's a legislative act, and a legislative act cannot be challenged in the court of law. So that's a dispute that is pending in the Delhi High Court. So there are about 30-40 odd batch matters which is just going on. So let's see when that comes. So broadly this is the overview, but I'm very happy to answer any queries if there is a... Yes. Yes.
Thank you very much,
Thank you.
Pragyan ji.
Thank you.
You oversimplified anti-dumping
Yes, sir.
laws.
Thank
We are really grateful to you. So here that arbitration SHAR 4 suddenly fixed.
Yes.
So it is in a hurry.
No, that's okay. I have time till 4, I said.
I request Dr. Sunil Agarwal, will give a vote of thanks for this thing. Sunil, please,
On behalf of the Friday group and Sesu sir, on all of us, I congratulate Sri Pragyan Pradip Sharma ji on being designated as a senior advocate, and it is our honor to have his lecture today on this anti-dumping issue, which is very close to our understanding also. In fact, recently, as on 4th of December, India, the DGTR has imposed anti-dumping measures on Vietnam and China.
Correct.
As far as that this Borosil renewal case.
Yes, absolutely.
There was a complaint filed by Borosil renewal regarding the solar panel anti-dumping measures to be imposed, and that is under consideration, investigation going on. And I think this very important measure under the WTO regime that is currently regulating the international trade is a part of the Article 6 agreement, where anti-dumping measures could be taken by the state to implement the WTO agreement. India, being a very important party to the WTO agreement, has enacted all these laws and implementing through the agencies like DGTR. And I think I will end up here only, and thank you once again, sir.
Thank you so much. Thank you.
And
It's been a pleasure.
Thank you very much, Sunil ji. So nicely explained. Before question of law, how many people really followed, understood this anti-dumping? Can you raise your hands? Can give a huge claps. Before
Yes.
take ready for question answers. Take your autograph. Any message you can write.
Okay.
Your autograph. As a senior designation, first time you addressed.
I hope